If you've ever wondered why our rights keep disappearing no matter which party is in power, this petition may hold the missing piece. I filed a petition with the United States Supreme Court, and in this video I'm going to walk you through it. This is not a small case. It's about restoring the very safeguards that were designed to stop government overreach permanently. If you're concerned about socialism, wokeism, or fascism, you'll see how this brief confronts them directly. If you fear tyranny from the other side of the aisle, you'll see how this case limits any government that tries to grow beyond the Constitution. In short, this petition returns power to the people. Along the way, I'll show you the secret deception about judicial power that enabled Roe v. Wade to slaughter millions of unborn children and why that fight isn't over. The false precedent that gave us mask and vaccine mandates, why plea bargaining is quietly gutting your 5th, 6th, and 8th Amendment rights, how legislators are tricking you into thinking you're free while stripping your protections one by one, and why the anti-polygamy trials against the members of the Church of Jesus Christ of Latter-day Saints are actually the central conflict that explains the erosion of every liberty we've lost since. This case is about far more than my personal situation. It's about the domino effect that has erased checks and balances, funded propaganda, and even enabled political violence and wars. I'll prove using the Constitution itself that the Supreme Court is not the final word on constitutionality. The founders never intended it that way. So don't just watch this as a legal fight, watch it as a roadmap. If we understand these protections deeply enough, we'll never let ourselves be shortchanged again. And whether the Constitution grants this petition or not, that knowledge may be the one thing that finally turns off the spigot of socialism and stops big government in its tracks. All right, so I have promised big on this petition, and I am going to deliver. So let's jump straight to the questions being presented to the court. Now, as we read this, I want you to engage your clue-finding brain and your founding father brain and look for checks and balances that could help protect against various types of overreach, including Roe v. Wade. Pick issues that you care about and just notice those connections to those things. And there is going to be a certain amount of legal terminology in here. I'm going to go ahead and just do my best to define those terms as we go. You are completely capable of understanding everything that is in the Constitution. This is why it was written, is so that we could use it to hold our government accountable. And so I'm going to start out, and if you have other terms that you want defined or questions that you want clarification on, please drop a comment and ask your question or provide your citation or other information or observations to help us make sense of this great big puzzle, because this is going to make a lot of sense as we go through. So I'll start with this term that gets used at the very beginning of the brief, stare decisis. It's a Latin term, and it means let the decision stand. It refers to a legal doctrine that judges should just refer to previous decisions and let those decisions stand, rather than issuing new decisions when the same topic comes up over and over again. And it's an expediency done for the sake of efficiency, but it's also based on the assumption that people in the past have more wisdom than we do in the present. And it's the force driving arguments of binding precedent. Precedent meaning whatever the courts decided in the past, binding meaning they're going to treat it as though it has some kind of a binding force, like the force of law behind it. This is why judges and lawyers refer to this as case law. It's a misleading term. It means essentially they're legislating from the bench. And so this brief actually attacks the heart of legislating from the bench. And if we understand these things, then we can actually act as an effective check between the branches of government. So, stare decisis, let the decision stand. It's the doctrine behind binding precedent, also known as case law. Questions presented. In Ramos v. Louisiana, this court, meaning the Supreme Court, held, stare decisis has never been treated as an inexorable command. And the doctrine is at its weakest when we interpret the Constitution, because a mistaken judicial interpretation of that supreme law is often practically impossible to correct through other means. So an inexorable command, meaning one that you can't, there's no loophole, there's no escape from it. So they're explicitly stating that stare decisis, binding judicial precedent, is basically not a thing. You can't enforce that on people as though it were stronger than the Constitution, specifically citing the Constitution and its protections need to prevail above assumptions about precedent. Stare decisis. So, question number 1. Do courts therefore err when they assert stare decisis as binding? Is there an explicit constitutional basis for the doctrine of binding stare decisis, especially when used to undermine constitutional guarantees such as rights to liberty and property and the presumption of innocence, as when it is invoked to deny a defendant a jury trial contrary to state and federal constitutions? So just very simply up front here, this was the case for me here. I demanded a jury trial, and the judge, the district court judge, told me to my face, we can't do that because I'm bound by precedent not to give you a jury trial. I said, well, that contradicts the Constitution, so I'm going to appeal this. So that's how we got here, is demanding a jury trial, and then this stare decisis doctrine, this binding precedent doctrine, was deployed as a weapon to deny a defendant his constitutionally guaranteed rights. This happens hundreds of thousands, if not millions of times every single year in the United States. This is a serious problem of pandemic proportions against the Constitution. So in essence, we're asking, well, which is more important? The Constitution itself, or judges patting themselves on the back saying that whatever some panel of judges decided 50 years ago must prevail above what the Constitution actually says? And this right here, by the way, if we didn't have this doctrine of binding stare decisis upheld by the courts, then Roe v. Wade could not have had the force of law, which it did. A judicial ruling was misinterpreted as though they had legislative authority, and that was what bound the states so that they could not issue laws against abortion. Question number 2. Does classifying a charge as an infraction or other designation or perceived ambiguity in the treatment of a case as criminal or civil, or any other heading such as an administrative proceeding, allow for bypassing jurisdiction, procedural safeguards, and constitutional guarantees such as the right to a jury trial? Now, how this came about right here is the Constitution of the United States guarantees a jury trial in every single criminal case, no exceptions. And what legislators and lawyers have done is they have invented new designations that did not exist at the time the Constitution was ratified, and then used those designations as an excuse to deny defendants their rights. We're going to see the exact trapdoor of wording and classifications and the statutory loopholes that they used to try to inflict that on us. So what you can read this question number 2 as saying is, I'm asking the Supreme Court, the Constitution grants all of these express guarantees to all of us. Can anyone in the government just change labels on things and say, whoops, you no longer qualify for this right? Because, for example, they'll say, well, it's not a criminal case. But they have to lie to do that, right? They have to distort the meanings of words. They have to bend them around backwards to where they make a full 180 and then a 360 to where they've doubled back on themselves, right? So are lawyers allowed to wordsmith to such a degree that they can just torture words and say you no longer have rights? This is extremely important. If you've ever been through the criminal justice system or the civil courts, you know how important it is that words retain their factual, constitutionally grounded meanings. Question number 3. Under what constitutional authority can a state mandate the confiscation of property or compel the purchase of securities or other commodities in a manner that contravenes enumerated taxation and regulatory powers and the due process clauses of both state and federal constitutions, and furthermore contradicts the principles underlying a state constitution's provision safeguarding free market operations? So what this is asking here is it's saying states can try to tell people, hey, you have to buy this product because we said so. Securities in this case meaning insurance. Saying you have to buy this insurance product or service. You have to buy this thing. We get to take means away from you at our sole discretion, even though we have a due process clause that says that we're not allowed to take property away from you without due process of the law. And we also have a clause in the state constitution here in my state of Utah that explicitly states that we shall have a free market. So no state intervention, right? And yet the state is intervening and saying you have to buy this product. So where did that go wrong? This right here is the key behind socialism. If you want to understand how socialism gets installed, you absolutely need to understand this argument, the false and misleading premises that lead us to embrace socialism by degrees until we wake up one day and if we're honest with ourselves, we realize, oh, we are already living in a socialized state. The government already has an effective monopoly over the economy. And this is exactly how it happens. And this was the underlying issue that triggered the other two. So these are the questions. Introduction. Our rights were dismantled from 100% to 1%. When is a crime not a crime? How much infringement can a right bear until it is no longer regarded as a right? Through newly invented labels and interpretations, governments routinely deny constitutional guarantees, including trial by jury and property rights, as in this case, circularly appealing to precedent while protecting trillion-dollar public-private partnerships from the rigors of a free market. On so recently. So that's part of the story, part of the backdrop behind how defendant rights were erased in the state of Utah. And originally, and the church, the brethren of the church always affirmed jury trials, and the people themselves upheld them 100% of the time until this forced constitutional draft was written and forced cultural changes were pushed on the people. All right, I'm going to move on. The Magna Carta, often touted as a model for the American Constitution, established that fines shall correspond to the severity of the offense, mirrored in the Eighth Amendment, that regardless of amount, no fines shall be imposed save upon oath of upright men from the neighborhood, analogous to the Sixth Amendment guarantee of a jury trial in all criminal prosecutions. So again, it's like the Magna Carta itself says no matter how small the fine is, the government doesn't get to get a cent out of you, or 1 pence or whatever it was back then, without the consent of your peers. Jury trial, right? Fines not individually amounting to large fortunes and other so-called petty offenses have been arbitrarily divorced from this promised protection, despite the right bearing no such qualification. It has been argued that for small fines, this is tolerable. However, this ignores cumulative economic realities. I would add, in addition to just the raw guarantees. But automobile insurance mandates, which is what my case is about, protect a market valued globally at around $1 trillion annually, a non-trivial portion of private property forcibly expended via a dubious precedent. And so this is in a typical American household, maybe 1 to 5% of your annual income is going to this insurance requirement. As illustrated in this case, the doctrine of binding precedent directly conflicts with express constitutional guarantees. This implies a defect in the doctrine itself. Binding precedent and jury trials are interrelated, as demonstrated in this case, where the former was used to deny the latter. Restoration of the constitutional standard requires unbinding judges to give actual judgment and juries actual verdicts, rather than outsourcing these through habit or external compulsion. Hence the three questions before the court: whether judicial precedent can be binding, whether constitutions justify limitation of jury trials in criminal cases, and the legitimacy of socialistic amercements, are all closely interrelated. Statement of the case. In 2022, Petitioner Stewart, hereinafter Petitioner, was served a notice of arraignment to appear for misdemeanor and infraction charges due to a traffic stop that occurred on or about October 2nd, 2022. At arraignment on January 3rd, 2023, he requested a jury trial. In a premeditated and plainly collusory response, the prosecutor immediately amended 2 of the 3 charges from misdemeanors to infractions. So I'm going to pause here and tell you what happened. So here I was being charged for driving without insurance and 2 subsequent charges that came about as a result of that. And I said, hey, I want a jury because, I mean, that's what the Constitution says. And I believe I'm right. I believe I can prove my case. And so I demanded that from the judge. And the moment I said I want a jury trial, the judge turned to the prosecutor and said, do you have anything to say about that? And the judge, the prosecutor said, without hesitation, he said, Your Honor, I move to amend the charges to infractions. Now, in the state of Utah, there's a statutory loophole. Even though the Constitution expressly states that all criminal cases shall have a trial by jury, there's a statutory attempted exception to that to try to overrule the state constitution that says no jury trial shall be had in the case of an infraction. So that's why this case has to do with the designations, the labels that they put on the crimes. That's why this whole thing opened with the question, when is a crime not a crime? So just by swapping out the label on it, suddenly the prosecutor was able to say, and the judge were able to say to me, well, you don't get a jury because the legislature says that you don't get a jury trial if it's an infraction, despite that being contradicted by the state constitution. And I have eyeballs, I can read, and so I'm just calling them to provide the constitutional protection that their entire job and their entire profession exists to protect. and they denied it in that way. So that was the trapdoor that they pulled on me, and I've seen them do this to others on more than a few occasions now. It's definitely just part of the system. The judge and the prosecutor, they're 100% on the same team. They're not opposed to each other at all, like we're taught in public schools, where they say, "Oh, the separation of powers between the branches of government means that they're going to provide checks on each other." It's a complete lie. As evidenced right here, the legislature, the judge, and the prosecutor representing the executive branch of government are all three allied. They're all on the same team, which is one of the reasons why they do not want a jury in the room. Because if there's a jury in the room that actually gets to decide the verdict, then their whole gig is up. They can't punish you over stuff that's dumb or rotten or unconstitutional if a jury is present and can actually think about those issues and intervene, weigh in on the topic with conscience. And so this is the thing, is we have a beast, a three-headed beast without any conscience that is devouring people whole. And the only way to stop it is to reintroduce juries into the mix to protect the people against the encroachments of all three branches of government. So that's what was going on here. And I can go ahead and explain just a little bit of why I was driving without insurance. My auto insurance app's auto pay feature had failed, and it didn't make me aware of it for a little while. I was unable to log into my app for a while because of some really squirrely stuff to where the website wouldn't let me log in and so on. So I was trying to work that out. But meanwhile, while I'm locked out of the app, it had failed. An automatic payment had failed for what reason I don't know, because my payment information was still valid. Anyway, it failed, and I was locked out of the app. I didn't get a notification for a while. My auto insurance company does send me mail. I don't recollect. I think they eventually did send me something. I don't remember when it arrived, but like they're so spammy with their mail that I would get like something every couple of weeks or something like that coming from them. And so I just didn't see mail coming from my automobile insurance company as terribly important, because, they're sending me stuff that's like way more frequent even than just a monthly statement. So anyways, that was the backstory behind this. And so here I am driving down the freeway and see these blaring lights and wailing siren coming up behind me, and he pulls me over, and I'm like, what's going up? And he had run my license plate and correlated it against a supposedly private company database that said that my automobile insurance wasn't paid up. And so I got this arraignment, and I decided I want a jury trial because I don't believe that's ethical to force people to purchase insurance. And I understand that public schools teach otherwise. You are welcome and invited to stick around to figure out how you can identify the difference between a tax that is allowable under the Constitution, that's pursuant to an actual enumerated power of government, versus one that is not. And I believe that that is a key distinguishing feature for telling socialism apart from stuff that's not socialism. There's a lot of confusion on that subject, and so I'm wanting to unpack and elucidate that, going through this worked example. All right, so the charges originally that were filed against me were operating a vehicle without insurance, driving on a suspended or revoked license, which the officer later modified to driving without a valid registration, since my license was in fact up to date. I had to go to the DMV to verify that. So I was very confused by that. And driving on a suspended or revoked vehicle registration. And again, all three of these charges emerged. They were consequent from this one statute, which mandated the purchase of insurance on motor vehicles operated on public roads. And the registration was revoked automatically due to lapsed insurance payment. So really it's just one underlying cause, and they're just trying to load all these charges onto me in typical plea bargaining fashion, where they try to intimidate you by charging as high as they possibly can and throwing as many charges as they possibly can at you, even if they're redundant, they don't care. They want to scare you into taking a plea deal so that you don't ever bring this before a jury, because if a jury hears it, then the jury can nullify the law, which is great because some laws are bad and should be nullified. Let's see. On February 8th, 2023, the petitioner filed a demand for a jury trial. The court denied the demand on February 16th. At an unconstitutional bench trial, and I should explain what a bench trial is and why it's unconstitutional. We'll get a lot more into the meat of that later. A bench trial is where it's just you and a judge. The judge is the judge and the jury and maybe the executioner. You get the common phrase, but And the reason it's unconstitutional is because the Constitution says that all criminal trials have to be tried by a jury. So, and this is what the judge gave me. She just said, "Do you want a trial or not?" And I'm like, "I want a jury trial." She's like, "Do you want a trial or not?" You know, that kind of forceful language, try to coerce you, strong arm you into waiving your rights. No, I never waived my rights. So, but you know, they forced this to happen anyway. So an unconstitutional bench trial in the district court on February 22nd, 2023, petitioner moved to dismiss the information amending the charges to infractions, which was just kind of a last-ditch effort to try to get a jury to hear the case. The motion was denied by the court. Petitioner endeavored to provide evidence of the guarantee of jury trial in all criminal cases and the unconstitutionality of insurance mandates. The court ended all discussion of law, alleging that the trial permitted petitioner to attest to facts of the case only, rather than raise constitutional issues or matters of law according to right. This admission demonstrates a systemic misunderstanding, namely that courts may arbitrarily refuse to hear matters of law or to refuse to allow a jury to hear and decide matters of law and fact. Petitioner made motion at trial to issue a notice of constitutional challenge to the Attorney General pursuant to Utah Rules of Criminal Procedure 12.1a. The court denied the motion. Claiming that only fact relative to law, not law or the constitutionality of law, was to be addressed in the hearing. The district court claimed that a binding precedent prevailed above constitutional guarantees. District court convicted appellant of all three charges summarily. Some will object to that terminology, summarily, because it's usually applied again to only civil cases, but summarily, again, bench trial, it was summarily decided. That is without a jury. Petitioner filed a timely notice of appeal on March 22nd, 2023. I'm going to pause here to say a little bit about how weird the trial experience was, because on the day of the trial, I had received a WebEx link, and of course I had the address of the courthouse as well, and which courtroom it would be held in. And I showed up in person, physically, to the courtroom, wearing my white shirt and tie and everything. And I was there early, so I could be there on time for my trial. No one else was there, except at some point, the judge and I guess maybe a clerk and a recorder came into the room, and maybe the prosecutor was there. I don't even remember. I don't think she was. Could be misremembering that. But like the courtroom was empty. Like all these seats around me were empty, and this was a really surreal experience, because in the movies, when you go to a trial, like it's a public trial, speedy public trial, right? And for one, this was like more than 4 months after the fact. 3 months after the fact. And, but also just to see that like no one from the public was even there to like express any interest in my well-being or keep an eye on the judges in the court and see what they're doing. But anyway, not only was that kind of spooky, but, the judge, like, as soon as she walked into the room, she like, her eyebrow was like, what? And she explained to me, she said, "You're not supposed to show up here in person. You're supposed to go back home and get on your computer and connect to this over the internet, and we'll do it remotely, and turn your video on, please." And I'm like, what? Can we no longer like show up in our courtrooms in person? And I get this was like a little bit after COVID and a lot of restrictions have been lifted and all, but like the fact that it was a post-COVID policy that like you could not show up in person for your public trial, that was really sketchy. And I've actually seen this a lot in these arraignment hearings and in the plea bargaining scenarios, is they are not public. Like you can in many cases, let me qualify that. You can in many cases go onto the website and get a link to a WebEx room and drop in there. But like I've done this on numerous occasions, and the judge, if the judge sees someone else on the call, he or she will be like, "Who are you? Identify yourself, turn on your camera," and stuff like that. Like demand to see you, because you're like not allowed to like eavesdrop, I guess, as a member of the public at a public trial. Anyways, really weird. I've had that happen a number of times, and even heard out of a judge's mouth, "You're not allowed," talking to one of my friends that I had showed there to support, who was being accused of something. And the judge says, You're not allowed to have anyone else in the room there with you. There isn't anyone else there with you, is there?" And they're like required to say no. And anyways, they try really, really hard to isolate you. That's the point. Anybody who has been through our criminal justice system has noticed this. They pull out all the stops to make sure you feel and are alone, without the assistance of counsel, without anybody on earth who loves you and who can see what's going on, to be there and help you, without anybody knowledgeable anywhere near you who can help you to stop what's going on, right? And tap the brakes and be like, whoa, 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 hold up, right? And definitely not anyone eavesdropping on a public trial to figure out what is going on and what these prosecutors and judges are doing to people in these dark internet closets. Anyway, that's a little bit of backstory. But let me continue on here. I can share these experiences all day, right? The Court of Appeals rendered an opinion on January 25th, 2024, ordering an affirmance of the district court's decision. Rather than rebut the plain wording of the constitutions or address the matter of circularity in resorting to precedent to say that precedent itself is necessarily correct or warrants obedience, notwithstanding legitimate matters of public right and outstanding constitutional challenges to the contrary, the opinion dodges these questions by transparently affirming precedent as a power unto itself, having no need to deal in or address the underlying constitutional matters involved, even when the authority of said precedent to the question is only presumed rather than established. And this is exactly what the prosecutor did when I appealed the case up to the Court of Appeals in Utah. Is he kept on citing this thing that was referred to as presumption of constitutionality. And the presumption of constitutionality is the precedent established by the courts that whatever the legislature does, they just assume that it's constitutional and you can't question it. You're not allowed to. And they never get around to actually examining the question to see whether or not the law is constitutional. So judicial review is dead in its tracks. If you wanted to restore judicial review and actually get bad laws removed from the books, you have to keep going and you have to understand this and you have to act on this knowledge. You absolutely must. This is not a drill. This is what I recommend that people do, honestly, is if you want to understand how our government has become corrupted, you just need to go around saying that 2 + 2 = 4. And when something isn't right, you stand up and you say it's not right. And somebody is being unjustly, unfairly accused or prosecuted. Their rights are being taken away. You've read the document, the Constitution, before, I hope. And you start to notice discrepancies. You call them out. And you call on those public officers in all the right venues. You show up to these hearings. You show up and you exercise your rights. You know, if you're a defendant, you say, I demand a jury trial. And that is the way that you can basically dive headfirst into the belly of the beast and observe as you're going through, oh, wow, those are the teeth. What big teeth? There's the epiglottis. There's the esophagus. There's the, okay, yep. And you're going down into its digestive tract so that you can observe firsthand the anatomy of how a police state operates and how a fake criminal justice system extorts you out of your rights, and to where there's like literally not a lever that you can push or pull anywhere that will actually deploy your rights to act as a protection for you and accompany other people on their journeys as they go through this. If you know somebody who's been accused of something, even if it's just as simple as a speeding ticket, insist on accompanying them to their arraignment, their pretrial hearings. Hopefully, they don't go down the path of plea bargaining, because that's a dead end. You'll lose all your rights right there, and all the way to trial and beyond. Like, stick with people through this, and you will begin to understand just how monstrous this beast is. And I'm saying this with all level-headedness. We are dealing with a police state, and we are dealing with an empire that has usurped power over the people. So I don't want to anybody to get hung up on that or think it's hyperbole or something like that. I'm just dealing with like this is, let me just be very flat here and state that's not constitutional, right? And state that's not constitutional. Petitioner filed a petition for a writ of certiorari on March 25th, 2024 with the Utah Supreme Court. The petition was denied by the Utah Supreme Court on May 24th, 2024, and a notice of remitter was issued by that court on May 29th, 2024. Reasons for granting the petition. Petitioner Stewart recognizes that under the Judiciary Act of 1925, a writ of certiorari is not regarded by the court as a matter of right, but an exercise of judicial discretion granted under compelling circumstances. I'm going to pause briefly here. Previous to the Judiciary Act of 1925, the Supreme Court, they were obligated, they were seen as obligated to hear most, if not all, cases, and they did hear a much larger percentage of cases that were brought to them, that were appealed to them before that time. And then the Judiciary Act basically gave them supposedly authority to just willy-nilly pick and choose which cases they were going to hear, which is why in 9 days they're going to decide whether or not to hear my case, not feeling themselves obligated in the slightest to actually overturn a bad precedent and say that they were wrong about something, or that someone else was wrong about something, and actually do the right thing and grant people their rights. So that's a problem. That's why I'm pointing that out, because that's not the way it was always done. Originally, yeah, if your rights were trampled on, you actually do have the right to appeal it all the way up and be heard and have relief granted if you're in the right. This case highlights 3 compelling questions of constitutional law of foundational and timely national importance. Number 1, whether it is constitutional to invoke stare decisis. Again, that's the let the decision stand thing, as though it had any binding power, saying basically precedent is law unto itself, case law, so-called, legislating from the bench. Number 2, whether administrative classifications, precedent, statute, prosecutorial discretion, so that's the prosecutor just deciding whatever he wants to do, or any other power may justly frame a contest in a manner denying any defendant rights, including the right to a jury trial. So you can just swap the labels and say you don't have your rights. And number 3, whether any government, state or federal, not acting within its enumerated powers of regulation or taxation is constitutionally justified in mandating the purchase of securities, that is insurance, or other items. Key discrepancies between the state's interpretation of these principles and those held by this court beg the use of supervisory intervention. The quandaries posed before this court are expanded as follows. Number 1, is stare decisis binding? Throughout the trial and appeals process, the doctrine of binding precedent was exercised unilaterally to deny the defendant the federal and state constitutional guarantee of a jury trial in a criminal case and to dodge other constitutional questions of paramount importance, outsourcing them to mere presumptions rather than due process or actual judgment. In Ramos v. Louisiana, this court held, stare decisis has never been treated as an inexorable command, and the doctrine is at its weakest when we interpret the Constitution, because a mistaken judicial interpretation of that supreme law is often practically impossible to correct through other means. So I'm going to summarize this slightly and say that the Supreme Court, basically, if the Supreme Court rules a certain way, decides that this is what the Constitution means because of precedent, and they feel bound by it or whatever, you really don't have recourse from that. You can't appeal a decision of the Supreme Court. And therefore, you have this dichotomy, and you say, well, here's the Constitution over here, and here's the Supreme Court over there. And if the Supreme Court is wrong in interpreting the Constitution, you're out of luck, right? And so it's urging caution to the Supreme Court itself, saying you should probably not apply things as though, just take for granted that you always have to follow this rule of stare decisis, of binding precedent, especially in constitutional matters, because if you make a mistake there, that's really hard to correct. Right? And that's true, right? This position directly conflicts with that held by the Utah Court of Appeals, ultimately citing this court's opinion for its justification that Stewart asks us to overrule precedent, arguing the precedent does not equal constitutionality, which is true. However, both this court and the district courts are bound by vertical stare decisis to follow strictly the decisions rendered by the Utah Supreme Court. We're going to get into that vertical term here. It's important, but there's a very edifying ramification we can get from it. It also conflicts with the district court's statement, echoing, quote, as a judge, I am required to follow the precedent set in front of me. So that's what the judge told me at the trial, the bench trial. That the opinions of this court and of state courts are therefore perceived to be instruments of a proactive judicial will enacted through an alleged binding force is a fact that cannot be mitigated by any argument. Deepening the quandary, this court's own past opinions have been cited as the alleged source of this binding force, creating a crisis of authority. Which precedent should prevail? The precedent that declares that stare decisis is not binding, or the precedent that insists that it is? To bind implies a lack of freedom to choose otherwise. Precedent is used both to reinforce and contradict the notion that deviation is not allowable. A deeper examination of the Utah Court of Appeals' cited justification from State v. Menzies reveals facets of the doctrine. This is where we get into vertical versus horizontal. There are 2 kinds of stare decisis. We note that the doctrine of stare decisis, as it applies to a court of appeals, has 2 facets. Vertical stare decisis, the first of these 2 facets, compels the court to follow strictly the decisions rendered by a higher court. Under this mandate, lower courts are obliged to follow the holding of a higher court, as well as any judicial dicta that may be announced by the higher court. Horizontal stare decisis, the second facet, requires that a court of appeals follow its own prior decisions. This doctrine applies with equal force to courts comprised of multiple panels, requiring each panel to observe the prior decisions of another. Horizontal stare decisis does not, however, require that a panel adhere to its own or another panel's prior decisions with the same inflexibility as does vertical stare decisis. Instead, although it may not do so lightly, a panel may overrule its own or another panel's decision where the decision is clearly erroneous or conditions have changed so as to render the prior decision inapplicable. So here what this is saying is there are two types. There's vertical and then there's horizontal. Vertical stare decisis says you have to go with what the higher courts above you say, no matter what, period. Like, you have no wiggle room there. But horizontal stare decisis is, it's got a lot of momentum and you really shouldn't change it, but if you really have to, you might be able to. You could argue that, right? So, and this is the dichotomy that was proposed by the Court of Appeals and by the judge, is that they're bound by this vertical stare decisis. So we're going to examine that as well as horizontal in just a moment to see whether it's actually true. The first citation above, Jaffrey v. Board of School Commissioners, states, "What is a court to do when faced with a direct challenge to settled precedent? In most types of cases, quote, it is more important that the applicable rule of law be settled than that it be settled right," close quote. That should make it cringe. "This general rule holds even where the court is persuaded that it has made a serious error of interpretation in cases involving a statute. However, in cases involving the federal constitution where correction through legislative action is practically impossible, a court should be willing to examine earlier precedent and to overrule it if the court is persuaded that the earlier precedent was wrongly decided. A judge looking at a constitutional decision may have compulsions to reverse past history and accept what was once written. But he remembers above all else that it is the Constitution which he swore to support and defend, not the gloss which his predecessors may have put on it." And this latter part, at least, of this quotation is very beautiful and true, that the Constitution should clearly prevail over opinions. Especially when, and as in my case, I'm invoking a matter of right. Peeling back the layers to Burnett v. Colorado Oil Gas Company, Justice Brandeis on that occasion wrote a dissenting opinion. The court was divided 5-4. Within that opinion, he noted, "Stare decisis is not, like the rule of res judicata, universal inexorable command." I'm going to pause and define this term, res judicata. That means the matter adjudicated. In a judicial setting, a court, the case before them is the res judicata, is the matter they are actually adjudicating. And the whole problem we have with activist judges and overreach and legislating from the bench and so on is where the justices have departed from res judicata. They're no longer saying what shall be the case and what their views on the law are in this particular case. Instead, they're making sweeping pronouncements to all other cases and to all other people, wherever they might be, of what their opinion is about what this law means, and thereby they are constraining legislatures and altering the force and weight of the rule of law, becoming a law unto themselves. It's legislating from the bench. Any departure from res judicata is legislating from the bench, because the only powers of the judiciary are to judge the matter at hand. They don't have power or authority to go and project that will onto someone else and say, well, we decided a case that said this, and that means we're going to apply this ex post facto interpretation onto you guys now, and you're no longer allowed to, no longer allowed to ban abortions, etc. And this is the power behind Roe v. Wade. So we need to understand this. Stare decisis is not, like the rule of res judicata, universal inexorable command. The rule of stare decisis, though one tending to consistency and uniformity of decision, is not inflexible. Whether it shall be followed or departed from is a question entirely within the discretion of the court, which is again called upon to consider a question once decided. Stare decisis is usually the wise policy because in most matters it is more important that the applicable rule of law be settled than that it be settled right. I would beg to differ with this. I think most reasonable people would beg to differ with this. The consistency of inappropriate choices is not more important than making choices right. It might be convenient. It's an efficiency argument, as I see it. I don't see any actual rationale given to back this up, other than that a lot of judges might be lazy. Anyways, it's an expediency. It's for efficiency, right? But it doesn't tend towards justice, true justice. This is commonly true even where the error is a matter of serious concern, provided correction can be had by legislation. So we're saying as long as you can go get help somewhere else, we're not willing to help you with it, right? As long as you can get help somewhere else, maybe they might punt on giving you help, on redressing your grievance. But in cases involving the federal constitution where correction through legislative action is practically impossible, this court has often overruled its earlier decisions, and in some cases, rightly so. The court bows to the lessons of experience and the force of better reasoning, recognizing that the process of trial and error, so fruitful in the physical sciences, is appropriate also in the judicial function. Hopefully not willful errors. Recently, it overruled several leading cases when it concluded that the states should not have been permitted to exercise powers of taxation which it had theretofore repeatedly sanctioned. In cases involving the federal constitution, the position of this court is unlike that of the highest court of England, where the policy of stare decisis was formulated and is strictly applied to all classes of cases. After such opinions, judicially delivered, I had supposed that the question to be settled, so far as any question upon the construction of the Constitution ought to be regarded as closed by the decision of this court. I do not, however, object to the revision of it, and am quite willing that it be regarded hereafter as a law of this court, that its opinion upon the construction of the Constitution is always open to discussion, when it is supposed to have been founded in error, that its judicial authority should hereafter depend altogether on the force of the reasoning by which it is supported. With as full respect for the authority of former decisions as belongs from teaching and habit to judges trained in the common law system of jurisprudence, we think that there may be questions touching the powers of legislative bodies which can never finally be disclosed, which can never be finally closed by the decisions of a court. It is more important that the court should be right upon later and more elaborate consideration of the cases than consistent with previous declarations. Those doctrines only will eventually stand which bear the strictest examination and the test of experience. I very much agree with that final statement, that it's more important to get it right when you have more experience, and don't be afraid of changing it when you know better. All right, this is me again. In contrast to res judicata, which refers solely to the matter adjudicated, stare decisis has since been presumed to have some proactive binding force upon cases and even legislation external to the matter actually adjudicated, which further hazards both ex post facto and double jeopardy, forbidden by the Constitution in Article 1, Section 9, Clause 3, and the Fifth Amendment, respectively, since the interpretation of laws may change as though the interpretation were itself a law, legislating from the bench. If a court broadens the definition of a crime, a person acquitted under the old interpretation may now fall under a new expansive or intrusive interpretation, despite previously escaping liability. The problems attendant to proactive rulings would disappear if we held to the core claim that whether to follow the doctrine is entirely within the discretion of the court, not an inexorable command whether it be a higher court or a lower court. In Burnett, Justice Stone also gave a dissenting opinion. It is plain that if we place emphasis on the orderly administration of justice rather than on a blind adherence to conflicting precedents, the Gillespie case must be overruled. No interest which could be subserved by so rigid an application of stare decisis is superior to that of a system of justice based on a considered and consistent application of the Constitution of the United States. It is notable that both of these dissenting opinions, including the primary one cited to affirm stare decisis, in reality strongly oppose its overly rigid application, and require its suspension particularly in federal constitutional matters, opening wide the door to future wisdom and experience to remedy past decisions, always with a view to correction. Wisdom ought to be preferred above habit. It is more important that the court should be right upon later and more elaborate consideration of the cases than consistent with previous declarations. Horizontal stare decisis appears in great measure to reduce to the assertions that each of the higher courts is responsible for its own precedent, and that to prevail against the argument of any supposed wisdom of the past, greater wisdom is required in the present. For seasoned judges more amply informed by such trial and error than any of their predecessors, this should pose no indomitable obstacle. Stare decisis may be of no weight beyond its persuasive power in the face of cumulative wisdom, and when experience has risen to extensive levels, reversals of some past opinions are almost invariably to be expected. Even recognizing that stare decisis may be usually the wise policy, it cannot be found to support the idea that it is irresistible. Hutto v. Davis approves the notion of vertical stare decisis. Quote, unless we wish anarchy to prevail within the federal judicial system, a precedent of this court must be followed by the lower federal courts, no matter how misguided the judges of those courts may think it to be. Close quote. A similar doctrine is reiterated in Rodriguez de Quijas v. Shearson, American Express, Inc. Quote, if a precedent of this court has direct application in a case, yet appears to rest on reasons rejected in some other line of decisions, the Court of Appeals should follow the case which directly controls, leaving to this court the prerogative of overruling its own decisions. Close quote. And so this is again affirming the notion of vertical stare decisis, that lower courts should never contradict the will of the higher courts. Whether vertical or horizontal, such a view explicitly imposes the will of a court outside of cases delivered to its jurisdiction, and begs the use of force in its application to extend rulings to other courts and panels, despite no constitutional provision justifying such forceful applications or proactive rulings beyond the actual cases, the res judicata, heard by a judicial body. This is true regardless of whether the matter in controversy may be deemed a federal constitutional issue. Stare decisis recently exposed another gap in its armor. In his concurring opinion in Gamble v. United States, Justice Thomas wrote, in my view, the court's typical formulation of the stare decisis standard does not comport with our judicial duty under Article 3 because it elevates demonstrably erroneous decisions, meaning decisions outside the realm of permissible interpretation, over the text of the Constitution and other duly enacted federal law. It is always tempting for judges to confuse our own preferences with the requirements of the law. And the court's stare decisis doctrine exacerbates that temptation by giving the veneer of respectability to our continued application of demonstrably incorrect precedents. By applying demonstrably erroneous precedent instead of the relevant law's text, as the court is particularly prone to do when expanding federal power or crafting new individual rights, the court exercises force and will, two attributes the people did not give it. Federalist number 78, cited there. We should restore our stare decisis jurisprudence to ensure that we exercise mere judgment, which can be achieved through adherence to the correct and original meaning of the laws we are charged with applying. Close quote. Are we therefore to understand that when judges undertake to cover a proceeding under the heading of allegedly binding stare decisis, whether vertical or horizontal, they're not acting as judges at all, but are rather punting on judgment without permitting due examination to take place, acting as mere perfunctory administrators of force and will, without a meaningful check on such power. Such is inherent in the notion of a binding precedent, or stare decisis treated as an instrument of force or will. Would this not violate the clear charter of the judicial office? If the assertion is rather that the courts are unbound, taking only advice from precedent, then ought their judgments to reflect such opinion only, rather than citing a supposedly binding cause? If a judge lacks sufficient wisdom to contradict a precedent, ought not his ignorance to be entered as the rationale for outsourcing judgment, rather than blind obedience to external compulsion? It has been argued, this is an important point right here, because it has to do with how you can appeal things and get justice that way. It has been argued that vertical stare decisis may be inferred from the appellate structure of the judiciary itself. That is, if a lower court rules a certain way, then on appeal, a higher court may overturn the lower court's decision. That the decision of the higher court in such cases may be of force is true in a sense. However, its purview is limited solely to the case at hand, and must be jurisdictionally sound in keeping with the role of the judiciary rather than constituting a sweeping pronouncement to be obeyed in all cases that appear similar in lower courts. Moreover, it is only true that such a vertical effect takes place if a court chooses to convict or affirm a conviction in a criminal case, thereby giving possible cause for an appeal, or if a party to a civil case wishes further appeal after a lower court's decision is rendered. If the lower court rules acceptably or with greater clemency, or if a jury acquits, no appeal is necessary, or in some cases possible. Hence, no pushback from a higher court would be warranted, nor could it be obtained in a criminal case. Hence, lower courts, by design in the appellate structure, necessarily have latitude to ignore the presumed opinions of higher courts when erring, if error it is to be called, on the side of fairness, of preserving defendant rights, the presumption of innocence, and upholding the Constitution over precedent. I'm going to read the footnote from the previous page. See Hutto v. Davis alleging that by defying a higher court's precedent, the Court of Appeals ignored the hierarchy of the federal court system created by the Constitution and Congress. That's the opinion alleging that vertical stare decisis comes from the appellate structure described in the Constitution. My argument and my petition contradicts that by showing very clearly that that can only be true in cases that end up being appealed. It is not actually true in cases where the lower courts opt to have greater clemency and uphold the presumption of innocence and decide matters more fairly than a higher court would. This is in fact desirable. It could even have the benefit of reducing the caseload for higher courts, since fewer causes for appeal from such decisions would issue. This phenomenon is worlds apart from proactive edicts from higher courts prescribing how lower courts ought to function, as it behaves quite differently from such a policy. So the claim of Hutto v. Davis is false. You can't bind lower courts to be inclement, that is, to rule harshly just because a higher court rules harshly, and so on, right? You can't bind a lower court to follow a certain precedent that would injure the person's rights, the individual's rights, just because a higher court, if they were to appeal it, might say so. And thus the lower judges can actually act as a check on the higher judges, whereas presently this is not the case. Presently, all the lower judges are bound to follow the precedent set by the higher courts. So basically under the current system, under the current mistaken interpretation, all of the lower courts in the land are basically bound to be carbon copies of the highest court in the land. That's not judgment. That's a vending machine for someone else's opinions. Hence, the appellate structure of the judiciary, in fact, does not affirm a notion of binding stare decisis. This is also consonant with the federal rule of individual and state rights having supremacy over federal powers, save for its enumerated few. That's from the 9th and 10th Amendments to the U.S. Constitution. The current doctrine creates conflicts here. That feedback may be offered to the lower courts on appeal of their decisions to a higher court is true. But where there is no appeal, no such feedback may be given, and consequently the dictum that lower courts are to follow precedents of the higher courts in proactive or binding fashion is fallacious on its face. Higher courts may teach lower courts by offering their published opinions as advice, but cannot bind them. I would just add here that the fact that through the Judiciary Act of 1925, the Supreme Court has reserved to itself a supposed right not to hear your case, the probability of them actually giving that feedback to the opinions and judgments of a lower judge are actually greatly reduced. And so there's far less of feedback. And one could argue that they created the stare decisis system, the forceful version of it, the vertical binding notion, as a means to try to counteract that, to say, well, we're too busy to give you feedback on all of these things. So we're just not going to hear most of your cases. We're not going to give you actual judgment. Instead, just go ahead and copy our notes right here and apply it in automated fashion. And that's exactly what we see the lower judges are doing. A further problem with stare decisis, both vertical and horizontal, is that it directly conflicts with each individual's oath of citizenship and each public officer's oath of office, wherein we enter a solemn oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, and bear true faith and allegiance to the same. Such allegiance and performance would be impossible if there were a higher allegiance than to the Constitution favoring any instruction contrary to the rights it protects. This includes binding precedent. Even if a panel of higher judges insists through lengthy precedent and numerous rulings that 2 + 2 = 5, all people are entitled, as well as duty-bound, to support the truth in contradiction to such claims. 2 + 2 = 4. A lower judge or juryman is derelict in his oath if he allows his faith and allegiance to a constitutional principle to be superseded by an opinion or edict from a higher officer or any other source. The Constitution itself is supreme above all such officers, as written in Article 6, no matter their position or tenure, and each citizen and officer has authority and responsibility already entered into under oath to oppose all unconstitutional acts and unlawful orders by their superiors, as General Alexander Doniphan refused the unlawful execution order of his superior officer, General Samuel Lucas, saying, "It is cold-blooded murder. I will not obey your order." If you execute these men, I will hold you responsible before an earthly tribunal, so help me God. In any event, if any support for preemptive vertical stare decisis or binding precedent in general is to be found, it would be circular to cite precedent as the justification for it. Such precedent must be chased to its uttermost root, and if the doctrine is merely advice, then it deserves to be cited as such, rather than as a controlling or forceful provision, or a matter of law unto itself. If, on the other hand, it had been a binding constitutional authority, citation to the Constitution itself without reliance on such a thing as precedent would be required to demonstrate it. I'm going to pause here. This is in our oath of citizenship. We all promise to support and defend the Constitution. We can't do that if we think that some panel of judges somewhere is above the Constitution. Attempts in this direction have certainly been made. Chief Justice Marshall, cited in Cooper v. Aaron, has been interpreted as follows. Article 6 of the Constitution makes the Constitution the supreme law of the land. In 1803, Chief Justice Marshall, speaking for a unanimous court, referring to the Constitution as the fundamental and paramount law of the nation, declared in the notable case of Marbury v. Madison that it is emphatically the province and duty of the judicial department to say what the law is. This decision declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, and that principle has ever since been respected by this court and the country as a permanent and indispensable feature of our constitutional system. It follows that the interpretation of the 14th Amendment enunciated by this court in the Brown case is the supreme law of the land, and Article 6 of the Constitution makes it a binding effect on the states, anything in the Constitution or laws of any state to the contrary notwithstanding. Every state legislator and executive and judicial officer is solemnly committed by oath taken pursuant to Article 6, Clause 3 to support this Constitution. Chief Justice Taney, speaking for a unanimous court in 1859, said that this requirement reflected the framers' anxiety to preserve it, the Constitution, in full force, in all its powers, and to guard against resistance to or evasion of its authority on the part of a state. Close quote. Despite lip service to the Constitution, where is the reliance on any constitutional authority here, without reliance on a judicial interpretation made to expand that alleged authority? No clause grounding the claim that judicial interpretation is the supreme law of the land in the constitutional text was made. It was baldly asserted. This doctrine directly enthrones a precept of legislating from the bench, even admitting that an interpretation is to be regarded as law, ascribing to the judiciary the powers of the legislature, and even overtly controlling the state legislatures. This is supposedly pursuant to Article 6, and yet the text of that clause makes no reference to any act, interpretation, opinion, or ruling of the judiciary. Not only are judges unauthorized to make proactive edicts, but the precedent itself also contains numerous contradictions, often unresolved and without recourse for resolution until a new cause is heard by the court, lending clarification. The judiciary is manifestly unfit to issue laws, let alone the supreme law of the land. The text of Article 6, Clause 3 of the U.S. Constitution is as follows. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Notably, it requires that the judges themselves be bound by said supreme law in every state, no matter if it is contradicted by the Constitution or laws of said state. Quoting Justice Marshall again. If the legislatures of the several states may, at will, annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery, and the nation is deprived of the means of enforcing its laws by the instrumentality of its own tribunals. Close quote. Would it not be a mockery of the Constitution to insist that a judiciary is itself capable of enforcing law or of legislating? Is what is constitutional a function of what is fashionable in the Supreme Court, or is it the express right and duty of everyone, to exercise his own conscience in upholding his oath or affirmation of office or of citizenship, to sustain the Constitution, free from the force or will of a judiciary. Can a man's rights be curtailed owing to a suit in which he was not summoned to appear as a party? That would violate due process. Or do judgments properly confer rights to be acquired, as Marshall said? The Bill of Rights is not an exhaustive enumeration of rights. The Declaration of Independence asserts as self-evident that human rights are God-given, and the Constitution itself manifestly grants no rights, but only enumerates exhaustively the limited powers of government and confers certain privileges and immunities in connection with those powers, secured by that compact to the citizens of the states. From Article 4, Section 2, Clause 1. No active resolution precludes, that's quoting Federalist number 78, speaking of the judiciary, that restriction, no active resolution, precludes and forever forbids legislating from the bench or enforcing an umbrella rule on others. Hence, the rule of stare decisis can be an instrument neither of force nor will. These are forbidden to the judiciary. It can only be taken as opinion outside of the res judicata. If we were to enforce blindly the interpretation in Hutto v. Davis, that's the one with the vertical stare decisis argument, lower courts could not exercise discretion even in matters of rights expressly protected under the Constitution, exposing officers to prosecution liability for having violated their oath of office to sustain the Constitution. Yet it never was a judge's prerogative to decide upon a criminal verdict. It has always been the exclusive purview of the jury. The Constitution itself grants nullification powers to juries. Further, the word judge derives from Latin jus dicere, meaning to say the law or to say according to the law, whereas verdict means true saying. Juror means one having made an oath. Hence, a juror is bound by oath to speak the truth. Truth and law are meant to mingle in this setting, but of the two, since truth and law are not always compatible, truth alone is to have binding power to punish the accused, acting as the final check against the abuse of the rule of law by resorting to the preeminent domain of conscience, which trumps all others. Is the bona fide supreme law of the land and its inexorable command of due process equivalent to anarchy? Addressing a concern in an earlier cited Supreme Court case where they intimated that it might be such. They equated the lack of binding stare decisis with anarchy, so this puts that to rest. Further compelling citations could issue, but petitioner considers that the quandary has been demonstrated. The present case offers a clear example of a situation where stare decisis ought to be suspended since it has repeatedly and falsely justified a direct and unconscionable violation of federal and state constitutional guarantees of rights. This contradicts even many interpretations of precedent that are biased towards binding strictly. Relief is always to be afforded in constitutional matters and never denied. A supposedly binding precedent that purports to be able to nullify the right to a jury trial violates the rule of law. Jury trial is the rule of law, per the supreme law. It is impossible for the fulfillment of a constitutional mandate to constitute anarchy, as contrasted with a failure to adhere to such rule of law. Quote, the trial of all crimes shall be by jury, close quote. Article 3, Section 2, Clause 3, U.S. Constitution. Juries are not bound by stare decisis and are the only body authorized to render criminal verdicts or to find damages in civil litigation above a set value when requested by either party. Judiciaries, by being granted too much power, feel they must rule excessively, making them a scapegoat for many state and national issues. The lightning rod for this problem is the jury. The supreme law of the land dictates that the conscience and consensus of the local impartial jury is the uniform, predictable rule of law that is to be meted out, absolving judges of the verdict and its attendant arguments. This brings us to the second question included in this petition. Number 2, can the classification of a charge as an infraction, ambiguity in its disposition as criminal or civil, etc., or precedent, circumvent proper jurisdiction and rights of the accused, for example, jury trial? The United States Constitution states in Article 3, Section 2, Clause 3, the trial of all crimes except in cases of impeachment shall be by jury. Petitioner was prosecuted for one or more alleged crimes, docketed as such in a criminal court. with a local municipality acting as the plaintiff, and yet was not accorded his defendant rights. Utah Rule of Criminal Procedure 17D was cited as the reason for this denial, which in its entirety states, jury trial in other cases. All other cases shall be tried without a jury unless the defendant makes written demand at least 14 days prior to trial, or the court orders otherwise. No jury shall be allowed in the trial of an infraction. If it is held that an infraction is not a crime, as is sometimes publicly asserted by the statutory distinction of being, quote, not classified, per Utah Code 76.3.105, then it appears no court has jurisdiction to try the case. The constitutions do not authorize governments to try offenses that are not crimes through a criminal justice system or to deny defendant rights by changing labels or headings. Designations such as infraction did not exist at the time the state constitution was drafted, guaranteeing the right to a jury trial in all classes of criminal cases. I'm going to read it here, Article 1, Section 10 of Utah State Constitution, trial by jury. In capital cases, the right of trial by jury shall remain inviolate. In capital cases, the jury shall consist of 12 persons, and in all other felony cases, the jury shall consist of no fewer than 8 persons. In other cases, the legislature shall establish the number of jurors by statute, but in no event shall a jury consist of fewer than 4 persons. In criminal cases, the verdict shall be unanimous. In civil cases, 3/4 of the jurors may find a verdict. A jury in civil cases shall be waived unless demanded. The relevant part of Article 1, Section 12 of the Utah State Constitution states, Article 1, Section 12, Rights of Accused Persons. In criminal prosecutions, the accused shall have the right to appear and defend in person and by counsel, to demand the nature and cause of the accusation, to have a copy thereof, to testify in the accused's own behalf, to be confronted by the witness against the accused, to have the compulsory process to compel the attendance of witnesses in the accused's behalf, to have a speedy public trial by an impartial jury of the county or district in which the offense is alleged to have been committed, and the right to appeal in all cases. The only way to skirt this requirement is to call the alleged offense not a crime, or to decide that infractions do not qualify as criminal prosecutions. But when is a crime not a crime? This case was prosecuted and tried by a criminal court. Jurisdiction is unsatisfiable without defendant rights. Arose by any other name, ... This matter fairly arises any time anyone is prosecuted under the guise of administrative proceedings, or whenever it may be questioned, is this a civil suit or a criminal one? If civil, the right to a jury trial attaches based on the value. Family, for example, is priceless. Speaking about family courts here, which are often tried civilly and also denied a jury trial, which is unconstitutional. But if criminal, there is no dollar amount necessary to incorporate the right. It always attaches. No other types of prosecutions may issue. If it is held that any of the alleged offenses is a crime, the constitutionally protected rights attach regardless of whether these are affirmed or supposedly contradicted by statute. Otherwise, it would have to be prosecuted by the government entity as the plaintiff under a civil heading, which is again a precedent invented by the courts, unoriginal to the constitutionally enumerated powers, and would still qualify for a jury trial given the sum in controversy regardless. This includes family court and administrative hearings. A guarantee the exercise of which is arbitrarily denied is meaningless. If a court cannot tell whether the case is criminal, the benefit of the doubt must favor the defendant and his rights. The principle of lenity. Lenity is the opposite of harshness. It presumes innocence and it favors gentleness as opposed to harshness. The principle of lenity is one of the most established in all jurisprudence. Ambiguity concerning the ambit of criminal statutes should be resolved in favor of lenity. This must also be true when the disposition of a case is uncertain, or as labels and designations morph away from the types of cases authorized under written constitutions, as in administrative proceedings, infractions, or any other heading. This court has previously ruled that in the presence of ambiguity, defendant rights should presumptively attach, affirming the principle of lenity with respect to outcomes, and not only with respect to administrative designations. Quote, deportation as a consequence of criminal conviction is, because of its close connection to the criminal process, uniquely difficult to classify as either a direct or a collateral consequence. The collateral versus direct distinction is thus ill-suited to evaluating a Strickland claim concerning the specific risk of deportation. We conclude that advice regarding deportation is not categorically removed from the ambit of the Sixth Amendment right to counsel. This is the Padilla v. Kentucky. They're saying that you can't just presume that somebody doesn't have rights protected under the Sixth Amendment if you're uncertain of whether something is a consequence of a criminal process or it's a direct or collateral consequence. You have to take into account where this leads, right? And if there are potentially criminal consequences arising from a case, then criminal defendant rights must attach. Kind of straightforward, pretty obvious. The relevance of these observations about attachment of defendant rights in an era of mass deportations and prosecutions of whole groups is pungent and timely. In consideration of whether a criminal court should hear a case under criminal auspices and afford the commensurate defendant rights, quote, "It is most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction if it should. The judiciary cannot, as the legislature may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties a case may be attended, we must decide it if it be brought before us. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution." Close quote. And this also very much tears into and debunks the Judiciary Act of 1925's claim that the Supreme Court is not obligated to hear all the cases that are appealed to it because they do fall within its jurisdiction. And this is referred to in Cohen's v. Virginia here as treason to the Constitution, that they decline the exercise of jurisdiction which is given. The question needing review pertaining to the district court is whether this matter of right be heard as properly within its criminal jurisdiction, or else failing to establish jurisdiction, it must capitulate the issue. If jurisdiction is established as a criminal case, all criminal defendant rights must attach per the federal and state constitutions. A government plaintiff in a civil suit is a contradiction in terms. While a jurisdictional gap has been afforded for charges denominated infractions, giving courts latitude to prosecute them but not afford defendant rights in such cases, we have in the precedent that, quote, "Constitutional rights cannot be denied simply because of hostility to their assertions and exercise. Vindication of conceded constitutional rights cannot be made dependent upon any theory that it is less expensive to deny them than to afford them." Close quote. That's in Watson v. Memphis. Brilliant. Any rationale pertaining to economy or efficiency regarding prosecution, including infractions used to deny rights, is invalid. If jurisdiction exists, the case must be heard, and the rights accorded, regardless of the dollar amount at stake. Again, this is United States Supreme Court precedent right here. This case shakes the very foundation of influences perverting Utah's original constitutional protections of jury trial and could set a national precedent, finally favoring written constitutions above unauthorized departures therefrom, even when given the color of law or of precedent. If national practices or precedent are ever cited as they have been by the states, it is thereby admitted that the federally guaranteed right attaches to the state since the federal opinion is embraced in questions pertaining to those rights. It is also admitted that the state's powers reserved under both the federal and state constitutions are imperiled by subjecting a right doubly asserted in both the federal and state constitutions, or by the state constitution alone, to a dubious or injurious precedent which reverses the constitutional order protecting and reserving all unenumerated powers to the states or to the people themselves. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Can a court in Utah defeat a state or federal constitutional demand for a jury trial for all crimes because of a practice of court precedent or of statutory loopholes? Quote, "Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them." Close quote. It's Miranda v. Arizona. Such is exactly the case here. The right to a jury trial in all criminal prosecutions is required by both the federal and state constitutions and contradicted only by statute, rules, and customary judicial practice, the challenge to which on constitutional grounds has been and continues to be summarily denied. Can a constitutional guarantee be limited by statute, and especially in such a manner as to make it immune to review? It is troubling that the courts, including the state Supreme Court, would allow statute to gatekeep or interpret constitutionally guaranteed rights in questioning or denying a right or requiring it to be restated as a so-called statutory right in order to be claimed. Statutes do not exist to grant, deny, or gatekeep rights. Such is not their prerogative. They exist to implement constitutionally enumerated powers of government and to provide mechanisms to safeguard rights. Quote, "A law repugnant to the Constitution is void, and courts, as well as other departments, are bound by that instrument." Close quote. Marbury v. Madison. In ironic collusion with the doctrine of stare decisis lies another doctrine, affirmed by the case history in one form as a presumption of constitutionality. I'm going to go ahead and read the footnote here because this is from my case in the Utah Court of Appeals. As in the appellee's brief in the Utah Court of Appeals case under review, which stated, it is presumed that a statute is constitutional and any doubts are to be resolved in favor of constitutionality. This is from the prosecutor. So he's saying, if there's a law in the books, you just presume that it's constitutional, and you just, if you have any doubt, just assume it's constitutional. Well, that directly contradicts the principle of judicial review. It's saying to the courts, nope, just stuff this down their throats. We, the prosecutors, will cram this down their throats, this fake doctrine of the presumption of constitutionality anytime they challenge the laws, to say that they can't do it, and then the courts nod their head and say, yep, because that's the precedent. You see that? So the courts are entrenching the false precedent created by the prosecutors to protect legislation from judicial review. This is collusion and conspiracy central right here, and you have seen this with your own eyes. No one can deny it. C. Brown v. Cox, in answer to a constitutional challenge against these infraction laws, which were used to justify the denial of a jury trial and upheld by invoking stare decisis. The prosecutor asserted that law is to be presumed constitutional, citing stare decisis. Thus, the two principles protect one another. Presumption of constitutionality is a practice that arrogates undue protection to the legislature from review, as recommended by the executive and affirmed by the judiciary, which justifies its oversight to presume constitutionality by the circular invocation of stare decisis, all without oversight from the people. Such utter failure to enforce checks and balances simply spells collusion across all three branches of government as documented by this case. The only way to break the cycle is to allow the jury to nullify the acts of all three. The presumption of legitimacy of precedent and the presumption of constitutionality of laws are at odds with the presumption of innocence. It is a boondoggle to continue to reinforce such circular precepts. As discovered in South Salt Lake City v. Mays, the exercise of the right to a jury trial in the state has declined massively, not least of the reasons for which would be the infraction trapdoor exemplified in this case. This is a highly illustrative example of an invention that did not exist and has been demonstrated not to have existed at the time the corresponding Constitution was written, but has subsequently been shoehorned in to prosecute the people while denying them their human rights as defendants. Quote, it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon, close quote. That's Boyd v. United States. Considering these facts and the exposure of the history of the exercise of this vital right by the Mays case, this question is ripe for review by the highest court in the land. The reduced exercise of jury trial through statutory loopholes and fictitious designations is such an encroachment. It is the court's duty to rectify and redress these assaults. Foundationally, the matter of jury trials is at the heart of the rule of law, and the ability of a populace to jumpstart judicial review, which is almost vanishingly rare otherwise. Petitioner raised this point on multiple occasions, that per the Charter of Juries, according to the Founding Fathers themselves, juries are empowered to hear matters of both law and fact when it suits them. Quote, if the question before the magistrates be a question of law only, they decide on it themselves, but if it be of fact or of fact and law combined, it must be referred to a jury. In the latter case of a combination of law and fact, it is usual for the jurors to decide the fact and to refer the law arising on it to the decision of the judges. But this division of the subject lies with their discretion only. And if the question relate to any point of public liberty, or if it be one of those in which the judges may be suspected of bias, the jury undertake to decide both law and fact. If they be mistaken, a decision against right which is casual only is less dangerous to the state and less afflicting to the loser than one which makes part of a regular and uniform system. That's Thomas Jefferson, his Notes on Virginia. This addresses the anarchy criticism in Hutto v. Davis. In this, the secret of the one true anchor is revealed. Government by the people through jury trials is not anarchy. It is the supreme law. Professor Suja Thomas called the American jury the legitimate fourth branch of government, lamenting its disuse. I would pause here and submit, maybe it isn't a fourth branch at all. Maybe the jury is the trunk of the tree of liberty, and we have these branches that are meant to serve us. And if we are not upholding those branches and checking them at every point, then the whole system of checks and balances collapses like a bounce house without any air going into it. Jury trial is that blower that's putting air into the bounce house so that it actually provides a check. So the three traditional branches of government actually check each other. Otherwise, we have observed by sad experience that they do not. The Mays case also showed that the practice of granting jury trials has waned from 100% of the time to a rarity in the present day. Jury trials were completely suspended in several jurisdictions during the COVID-19 pandemic. To demonstrate the irresistibility of the observation in the previous section that binding precedent effectively confers upon judicial rulings the weight of legislative authority, it cannot be argued that the Court of Appeals in this case did not treat the opinions of the courts about jury trials as though those opinions had the weight of law. Similarly, the judiciary in the Mays opinion and in the present case granted powers which were not theirs to give, presuming the legislature competent to interpret and review its own laws for constitutionality, a power exclusive to the judiciary. This trend would transform the whole government into a monolith, having no independent branches. A sitting president has declared intent to impeach so-called activist judges and replace them with partisan picks, consolidating the powers of all three branches of government under the unchecked management of a single party. To consolidate power under any head invariably leads to what James Madison warned was the very definition of tyranny, and that's in Federalist number 47. The Supreme Court has incorporated nearly all of the protections declared in the Federal Bill of Rights under the Due Process Clause of the 14th Amendment, but arbitrarily excluded the grand jury and so far has failed to uphold the full trial jury requirement against state overreach in all criminal cases. No citation to the Constitution itself has been advanced to justify these failures to incorporate rights against state encroachment. Some argue that grand juries and trial juries are merely procedural, not substantive, but similar arguments were rejected for the right to counsel and unanimous juries, Gideon v. Wainwright and Ramos v. Louisiana, respectively. An extra-constitutional doctrinal rationale rather than a constitutional rationale was given for this arbitrary limitation. Essentially, the circular precedent conundrum this petition exposes. The precedent of incorporating protections of certain rights against state encroachment directly conflicts with other precedents of this court wherein states are deemed to have sweeping police powers without a state constitutional dispensation. Arbitrary selective incorporation is a false doctrine on its face. Behind the dismantling and erosion of these unincorporated institutions, we find a government most paranoid against the possibility of actual oversight by the people. Attacking this power. Number 3. What authority allows the state to compel purchase of securities or other items contrary to due process in the Utah Constitution's Free Market Clause? The Fifth Amendment to the United States Constitution states in part, "No person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." This is echoed by the Constitution of the State of Utah. In National Federation of Independent Businesses v. Sebelius, Chief Justice John Roberts, delivering the opinion of the court, said, "Congress has never attempted to rely on that power to regulate interstate commerce to compel individuals not engaged in commerce to purchase an unwanted product. The individual mandate, however, does not regulate existing commercial activity. It instead compels individuals to become active in commerce by purchasing a product, on the ground that their failure to do so affects interstate commerce. Construing the Commerce Clause to permit Congress to regulate individuals precisely because they are doing nothing would open a new and potentially vast domain to congressional authority. Everyday individuals do not do an infinite number of things. In some cases, they decide not to do something. In others, they simply fail to do it. Allowing Congress to justify federal regulation by pointing to the effect of inaction on commerce would bring countless decisions an individual could potentially make within the scope of federal regulation, and under the government's theory, empower Congress to make those decisions for him. Indeed, the government's logic would justify a mandatory purchase to solve almost any problem." All right, and now we're going to get into the socialism aspect of this, insurance mandates, and particularly, I want you to understand, this isn't limited to automobile insurance mandates. The federal health insurance mandates under Obamacare were actually justified using the argument that the states had already imposed various automobile insurance mandates. So if you understand the underpinnings of the one, you can understand the other. You'll understand why our healthcare costs have gotten so huge, and also why we can't afford to own homes anymore, because These expenses have gotten so out of control they never were this big before. Compulsory purchases impose immense overreach. In their dissenting opinion, the court was divided 5-4, Justices Scalia, Kennedy, Thomas, and Alito wrote, quote, "If Congress can reach out and command even those furthest removed from an interstate market to participate in the market, then the Commerce Clause becomes a font of unlimited power, or in Hamilton's words, the hideous monster whose devouring jaws spare neither sex nor age, nor high nor low, nor sacred nor profane." Close quote. That's what we see happening. Both sides rule out the Commerce Clause, yet the ruling citing tax powers is tenuous at best. See Bailey v. Drexel Furniture Company and Perry v. Sinderman. The government may not deny a benefit to a person on a basis that infringes his constitutionally protected interests. Insurance mandates clearly violate due process because they constitute presumptive judgments and exceed enumerated powers. The underlying rationale is that an entity poses a liability upon society and must therefore be compelled to pay proactively to subsidize potential future damages, speculatively and without a conviction or any requirement to demonstrate guilt or actual injury. Hence, due process is directly violated. The value judgment that people are a liability finds its origin in the Communist Manifesto, not in the Constitution. Criminal courts have jurisdiction to try cases involving violations of criminal law on the roads, and civil courts have jurisdiction to award damages in suits between private parties. Hence, compulsory insurance purchases subsume the proper province of the courts in settling disputes, sidestepping due process. It also runs afoul of Article 1, Section 10. No state shall pass any law impairing the obligation of contracts. A compulsory contract is not freely entered into, but a law imposing insurance mandates impairs the obligation of contracts by substituting its own terms that are fundamentally incompatible with a free market. This court held that governments do not have authority to prevent individuals from entering contracts freely. Consistent with both sides of the Sebelius decision, the imposition of a state-mandated contract in a market is mutually exclusive with the ability to enter or refrain from entering such contracts freely. By assignment and presumption of liability, and similar to the issue of denying jury trials, insurance mandates violate the presumption of innocence. This court has previously held that a state has no right to demand or retain fines or damages without a valid conviction. Further, absent a final conviction, one is presumed innocent. And here's a list of cases that forbid prejudgment attachments and so on. That is to say, fines or penalties which are owed prior to a completed judgment and verdict. This contrasts with the legitimate tax powers of a government. Legitimate taxation must be pursuant to the enumerated powers of the Constitution of a government, be properly collected as such, and appropriated by the authorized body and used for the specified purposes within the enumerated powers, with full representation in government expressing the consent of those taxed. It has been argued that taxes to support military and police forces may constitute presumptive judgments similar to those levied by insurance mandates. However, unlike personal or property insurance or liability requirements of such mandates, military and police forces do not exist to punish individuals presumptively or extract damages for assumed liability. On the contrary, liability must always be established individually by due process of the law, notwithstanding legitimate taxation for the purpose of raising a temporary army, funding a police force, or enacting trials. These latter meet the description of duty as their sole prerogative is to protect rights, not to infringe on them. Laundering of liability through a socialized fund or collectivized damages stemming from presumed liability are not pursuant to enumerated powers. Socialism is not and cannot be lawful under the Constitution. The Sebelius decision sidesteps the fact of enumerated powers despite this court's precedent elsewhere, directly contradicting the use of tax powers to coerce compliance. For example, in United States v. Butler, where the court held that Congress's power to tax and spend must be for purposes authorized by the Constitution. Quote, "The power of taxation, which is expressly granted to Congress, may be adopted as a means to carry into operation another power also expressly granted, but not to effectuate an end which is not within the scope of the Constitution. It is not intended that this provision grants power to regulate agricultural production upon the theory that such legislation would promote the general welfare. The government concedes that the phrase, to provide for the general welfare, qualifies the power to lay and collect taxes. The view that the clause grants power to provide for the general welfare independently of the taxing power has never been authoritatively accepted. Mr. Justice Story points out that if it were adopted, it is obvious that, under color of the generality of the words, To provide for the common defense and general welfare, the government of the United States is in reality a government of general and unlimited powers, notwithstanding the subsequent enumeration of specific powers. The true construction undoubtedly is that the only thing granted is the power to tax for the purpose of providing funds for payment of the nation's debts and making provision for the general welfare. The arguments of this court's predecessors and other courts to uphold insurance mandates frequently rely on appeals to general welfare, and as just demonstrated, the proper definition of general welfare and other vague phrases is of paramount importance. Utah's Constitution states, Article 12, Section 20, free market system as state policy, restraint of trade and monopolies prohibited. It is the policy of the state of Utah that a free market system shall govern trade and commerce in this state to promote the dispersion of economic and political power and the general welfare of all the people. Each contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade or commerce is prohibited. Health and public safety is also a rationale cited in the order of affirmance in Appendix C for affirming regulatory control over sundry vehicular fares and purchasing decisions, but there is no wording in the state constitution conveying power to regulate on this basis, nor even identifying it as an objective of the said government, the sole exceptions being for state employees, which are not the public, or in addressing the suspension of the privilege of habeas corpus. No broad authority is delegated on this topic. The order also cites general welfare. The only things the state constitution has to say about public general welfare is that all political power is inherent in the people, that they have the right to alter government for their own public welfare, and that a free market is vital to the condition of general welfare by definition, according to Article 12, Section 20. These phrases exactly state the constitutional matters in controversy in this case, and were summarily disregarded on the pretense that precedent may without limit overrule such concerns as are explicitly identified by the framers of Utah's Constitution as constituting our general welfare, in the name of general welfare. Being required to pay into a socialized fund not among the enumerated powers is not a legitimate implementation of general welfare. In Massachusetts v. Environmental Protection Agency, this court ruled that the standing requirement to demonstrate a concrete, particularized injury applies to the states as well as to private organizations and to individuals seeking redress. This conflicts with the supposition that a state may levy damages presumptively or speculatively under whatever pretense. In Bivens v. 6 Unknown Named Agents, the court recognized an implied cause of action for individuals whose Fourth Amendment guarantees were violated by federal officers, demonstrating that standing is satisfied by the injury of constitutionally guaranteed rights, even in the absence of tangible damages. See also Spokeo Inc. v. Robbins, reinforcing that the injury in fact requirement extends to non-tangible violations of rights. Prepayment of speculative or presumed damages is not pursuant to any enumerated power. Hence, the burden of standing by governments seeking presumptive damages in disguise as a tax or mandate, etc., has not been satisfied, while the standing of the citizens to sue their governments for infringement upon their rights is fully satisfied per the court's own rulings. The injury of the rights of a few is an injury in fact to the rights of the many. Even under populism, injury against the few is mere tyranny antithetical to constitutional government. A government empowered to persecute minorities routinely shifts the window of minority to cover, in turn, the whole population. These clear and inherent limitations on state and federal power conflict with other precedents that seek to invent general, unenumerated powers and confer them upon the states. In Munn v. Illinois, the court upheld state regulation of private businesses affecting public interests, asserting broadly that states possess inherent police powers to regulate private property for the public good. In their dissenting opinions, Justices Field and Strong wrote, "It is true that the legislation which secures to all protection in their rights and the equal use and enjoyment of their property embraces an almost infinite variety of subjects. What is termed the police power of the state, which from the language often used respecting it, one would suppose to be an undefined and irresponsible element in government, can only interfere with the conduct of individuals in their intercourse with each other and in the use of their property, so far as may be required to secure these objects." The decision in National Federation of Independent Businesses v. Sibelius doubles down on a misleading definition of federalism. The federal government has expanded dramatically over the past 2 centuries, but it still must show that a constitutional grant of power authorizes each of its actions. The same does not apply to the states, because the Constitution is not the source of their power. The Constitution may restrict state governments, as it does, for example, by forbidding them to deny any person the equal protection of the laws, but where such prohibitions do not apply, state governments do not need constitutional authorization to act. The states thus can and do perform many of the vital functions of modern government, punishing street crime, running public schools, and zoning property for development, to name a few, even though the Constitution's text does not authorize any government to do so. Our cases refer to this general power of governing possessed by the states, but not by the federal government, as the police power. Close quote. Did you notice a poison pill there? Just, come on, take a step back. The same does not apply to the states because the Constitution is not the source of their power. Of course, the federal Constitution is not the source of the state government's power. The state constitutions are. And right here, we have federal government Supreme Court precedent in 2012 used to shove Obamacare down our throats, the Affordable Care Act, pretending that the federal Supreme Court gets to tell the states that they don't have to adhere to their written constitutions. And there is a misleading citation to the Federalist Papers here that I'll clarify in just a moment. And they do allude to something that is stated in the Federalist Papers, but they misstate it so egregiously, and we're going to have to unpack that in just a moment. States have drawn from this copious federal grant of a supposed general police power of governing, allegedly reserved to the states by the 10th Amendment, ignoring its further restriction, or to the people, and the principle of government by the people in defining their powers. This is not federalism at all, but overt usurpation by the state governments under the false assumption that they may claim all power not explicitly assigned to the federal government. State governments are also limited governments, bound not only by the federal, but also their respective state constitutions. See Bush v. Gore. Jacobson v. Massachusetts in 1905 held that states have power to impose mandatory vaccinations to protect public health, under the broad general heading of police powers, which are not necessarily conferred on states by their people. Sweeping power is often only assumed, asserted, or pretendedly conferred by the federal government, which is not how states' rights or federalism function. Legitimate governments operate on the exclusive basis of enumerated powers and consent of the governed. States are no exception. Insurance mandates pursuant to fictitious or overly broad police powers, constitutionally ungrounded definitions of general welfare, commercial regulation, tax powers, presumptive judgments, or another disguise are not lawful. They are socialistic, confiscatory, and perverse. Summary of reasons to grant the petition. Petitioner respectfully asks this court to remand the case for a constitutional jury trial and to repudiate the doctrine of binding precedent. This would restore stare decisis to its constitutionally compatible value as a potentially helpful suggestion, rather than a proactive mandate in excess of enumerated powers. Precedent offers a veneer of consistency, but it can exert no binding influence to constrain conscience, negate oaths of office or of citizenship, quash juries, or nullify constitutional guarantees. Defendant rights must attach in every case to which a government-connected entity is a plaintiff, fully incorporating the Fifth and Sixth Amendments whether the case is styled as civil, infraction, or otherwise. This petition calls on the court to affirm three crucial principles. Number one, that stare decisis is not binding, especially where it conflicts with the Constitution and in matters involving individual rights. Number two, that jury trials may not be denied over statutory or administrative classification, claimed civil status, or judicial policy. The right belongs to the people to exercise, not to courts, legislatures, or prosecutors to deny. Number three, that no government has authority to compel transactions such as insurance mandates absent enumerated constitutional power and due process. An end to binding precedent is necessary for the preservation of the American people and the institution of the judiciary itself. As George Washington refused the crown of kingship, the judiciary must also retire its scepter of supremacy and defer to the Constitution itself. Jury trials incentivize the proper application of judicial review, strengthening the judiciary against overreach from other branches. Today, judicial review is almost vanishingly rare. This is not due to any shortage of unconstitutional executive acts or legislation to review, but rather to an inadequate incentive structure in the absence of jury nullification. The promised checks and balances of the nominal separation of powers are only a classroom myth, unless acted upon by an external force, namely the will of the people. Juries also limit the scope of rulings to res judicata, insulating the judiciary against calls for impeachment originating from its own overreach. Without the citizen jury properly constituted and unfettered, Government invariably usurps the roles of judge, jury, and executioner unto itself. The presumption of innocence must prevail above presumptions of constitutionality and precedent. Efficiency cannot justify its erosion. A predictable but unjust process is no substitute for the proper rule of law. Jury trial is the consistent application of the law required by the Constitution. Today, we are rapidly arriving at a police state. Immediate intervention to restore constitutional safeguards is required. Subsidies and economic coercion are simply socialism, which is theft. Theft destroys families. Erasing First Amendment protections on religious freedoms has paved the way for the entire dissolution of defendant rights and all human rights, which are God-given. Restoring these protections is necessary to the preservation of freedom and constitutional government. Socialized programs are all anti-family and hence anti-civilization, and we must end them or they will end us. Signed by Seth Stewart. It's my proof of service. That's the end of it. Please let me know your thoughts. I hope you noticed the connections to Roe v. Wade. I hope you noticed the connections to the judicial overreach scandals, and I hope you noticed the connection to illegal immigration, and frankly, how dangerous a police state is, because if the government can just take away your money, increasing amounts of it over time, just because they said so, and because they're all patting each other on the back, we got major problems. All three branches of government are colluding and conspiring with each other. This brief proves it. It proves that jury trials would actually thwart the consolidation of power across the branches of government, and it would restore the promise of checks and balances between the branches of government. Without trial by jury in the loop, none of those checks and balances in reality happen. So I hope and pray that you will help to restore the republic, that you will understand these matters deeply. Don't worry about all the citations and memorizing this thing and that thing. Just there are points in here that you can share with anybody. If you understand them, you're able to share them. And it really does help to plead for those who are accused and to try to help those who are facing the criminal justice system go ahead and jump down the beast's throat. I would like to point out, just to hopefully act as a little bit less of a scary item here, in my case, actually, it was good for me, even in the immediate term, to demand a jury trial, because then the prosecutor amended the charges to infractions. So even if you're not granted a jury trial by demanding one, they lessen the severity of the case because they know they're bluffing. They know they are bluffing. And that's at least the way things are currently structured in Utah, at least as of, I guess, 2.5 years ago when I had this trial. So 2.5 years ago, and this is finally getting to the Supreme Court. So thank you very much for your attention. And please, let's keep the conversation going. Thank you.